in your opening statement, you talked about the 2007 OMB report to Congress. What was the cost between 2001 and 2006, and what was the cost over the previous 20 years? You mentioned that there was a 47% deduction, and you may not have those figures now, but I think that would be interesting to actually have those figures.
I'll get them to you. I don't have them right here, but I'll get them to you.
Okay. And also, the other question is, you mentioned, and yet the average yearly net benefits of new regulation has increased substantially. Can you explain what one of those might be?
What one of those regulations might be?
That's got a positive net benefit to somebody?
Our report to Congress lists the regulations of the previous years, and so it lists the costs and benefits. For the most part, we try to make sure that every regulation we issue does have net benefits unless otherwise constrained by law. There are some statutes that say you can't really consider those factors, but to the extent that agencies are allowed to consider them, we work with them to try to make sure they do.
Okay, but do you have any examples of what those might be? Could you get some examples? I mean, and show me kind of how you go through and try to determine what the net benefit is, and how that's, I guess, associated with who the regulation is placed upon.
Well, I think that's a very good question, because sometimes the benefits accrue to different people than the costs accrue to. So, for example, environmental regulations will often have very large net benefits, and the benefits are social benefits over several hundreds of years, whereas the costs may be falling on people's, particularly small businesses today. Others, the benefits and costs are borne more by the same people. For example, our vehicle fuel efficiency regulations, the benefits are expected to accrue to drivers who will save money in gasoline if they have more fuel-efficient cars. One thing I should note is on environmental regulations and occupational safety and health regulations, Tom's office under SBREFA, the Small Business Regulatory Enforcement and Fairness Act, gives Tom's office and a small business panel the opportunity to get involved and focus right in on what are the impacts of this on small businesses, even before I see it for review, so at an even earlier stage of review, but for those two agencies in particular.
Well, I'm very familiar with both those agencies, and trust me, we'll have people wearing bubbles before it's over, and they won't be able to work. The other thing I wanted to comment on, you had talked about the flexibility for community drinking water systems. I'm very familiar with this. In fact, in one of the counties I represent, they basically had to run a water line out there, very expensive for the homeowners because it was a small drinking system. You have in here that it was started in 1996 when an amendment to the Safe Drinking Water Act came up. And you talked about that the nominator had mentioned that there was really no way, or that it had never been found to be unaffordable. In other words, all the different tests that you had to go through, it was really impossible to prove to the EPA any of these things. And you said that this nomination is similar to a reform recommended by OMB by the public in 2002, which was approximately 6 years after this came out. And then you say, and we are also interested in working with advocacy and EPA to see that this nomination is pursued to completion. It's 2008. It's been 12 years.
Mm-hmm. Yes, and it's a high priority of mine personally and Tom's personally, but there are different legal interpretations of how to use the Clean Air Act, and I think it remains to be seen whether we actually see that finished this year. I would like to very much.
Mm-hmm. Well, you can understand what the concern might be in trying to look at some of these if it takes you 12 years and you hadn't done it yet. And I'm assuming this has gone through different administrations and so forth and so on. And I think that in itself is a problem. Mr. Sullivan, you and I had a great conversation the other day, and I'm going to ask you the same question I asked you in my office. How many regulations have been done away with during your time at the administration?
Mr. Westmoreland, I'll give you the same answer, although with a little bit more research that I've had the time.
Good, you found one?
I did. I did. Well, first of all, the Regulatory Flexibility Act that my office oversees really does put the responsibility on the agency to make a final decision. And I think that's important for the committee to absorb, is that I try to lead agencies to the right place. I try to give advice on how their actions will impact small business. With respect to Section 610, I try to give advice on how their existing rules may be out of date and how to reform them to help small business. But ultimately, it's their decision, and we use every tool possible to convince agencies to do good for small business. I would have to say, in direct response to that question, we're not always successful. And because of that, we don't have very many rules that we have done away with. However, since I have been Chief Counsel for Advocacy, or in the last several years, there have been a few notable rules that do show Washington, D.C.'s sensitivity to how regulations impact small business. The first is one that I worked on extensively when I was with NFIB, and that was the ergonomics regulation that was passed under the last administration. My predecessor, Jerry Glover, was courageous in standing up and telling his own administration that that was not good for small business, and he did not prevail. However, thanks to Congress and the President, they overturned that rule. So that's one, but it did take an act of Congress. One that's a little bit more recently, and I do view as EPA's responsiveness to small business concerns, was several years ago, they were considering requiring every pollution report to be filed electronically. And small businesses were very concerned that this would cost close to $40,000 to update their computer systems, receive training, and they pleaded with then Governor Whitman. Governor Whitman was the head of EPA at the time. They said, you know, this may be a good idea at some point. When the technology highway is such that every small business has the exact software, exact computer systems, maybe this will make sense, and maybe it will be an efficient way to submit pollution reports. But right now, it will devastate us. And we presented that material to the Environmental Protection Agency, and because of her leadership, they withdrew the rule. So that is one that I'm very proud of. And we, with this R3 initiative, we're looking for other rules that may be duplicative or out of date that we also can work with the small business community and agency leaders to say, maybe we don't need that rule anymore.
And Mr. Sullivan, that's the NP, it's the national, the pollution.
Oh, the actual rule that they were thinking of doing, it has a long acronym that is pronounced CROMAIR, but it has to do with record keeping on a whole slew of different environmental reports that are required. It's not restricted to one particular clean
Because
water.
there is a national permit that you now have to get for stormwater runoff, even though cities and counties and states have a permitting process. You now have to have a national.
Yes, Mr. Westmoreland,